This video is part of a series intended to help citizens, members of the media, public officials, or anyone acting on their behalf to better understand Florida's exceedingly broad Public Records Act. These videos may be used by anyone and may be freely distributed without charge. I am not an attorney. I am not qualified, nor am I authorized to give legal advice to the public, so I don't. Any information provided by me in person, on video, or through fogwatch.org is readily available from the Florida First Amendment Foundation and the Florida Attorney General's Office of Open Government, as well as many other sources online. In 1990, in what is commonly referred to as the White Sox case, the Times Publishing Company filed suit against the city of St. Petersburg and the Chicago White Sox in order to gain access to certain public records. The court found that the defendants had engaged in complex legal and logical gymnastics in an effort to avoid compliance with the Public Records Act. Specifically, the city and the White Sox arranged to maintain public records at the offices of the White Sox in Chicago, Illinois, so that the city could subsequently claim not to have custody of such records. The second DCA held that an official charged by law with maintenance of public records may not transfer actual physical custody of the records and thereby avoid requests for inspection under the Public Records Act. In 1996, Mr. and Mrs. Reckler were engaged in civil litigation with a third party. During their litigation, they made a series of public records requests to the town of Manalapan. After numerous delays in the production of the records, the Recklers filed suit against the town in order to force compliance with the Public Records Act. The fourth DCA held that the production of public records requests is ministerial, as it is a duty imposed by Chapter 119. Additionally, the Recklers have a legally vested right to the production of those documents, and their production is non-discretionary. In 1998, Booksmart Enterprises filed suit to compel Barnes & Noble College Bookstore to produce public records that reflected the textbooks selected by the faculty of Florida International University and Florida Atlantic University, both public institutions. Barnes & Noble had created the records in connection with a contract with the schools. The third DCA found that a public agency may not avoid its obligations under the Public Records Act by contractually delegating to a private entity that which would otherwise be an agency's responsibility. In 1999, a newspaper, the News Journal, sought access to public records within the custody of the Halifax Hospital Medical Center. The hospital refused access, citing an exemption of their written strategic plans. Although such an exemption was created by the legislature, the Florida Supreme Court invalidated the exemption on the grounds that it was unconstitutionally vague. In essence, Florida's High Court concluded that the legislature is obligated to construct exemptions to Florida's Public Records Act so as to be no broader than necessary to accomplish the stated purpose. In 1999, the News Journal sued Memorial Hospital west of Volusia in order to gain access to certain public records. The hospital, which was publicly owned, had been leased to and was operated by a private corporation. On appeal, the Florida Supreme Court held that when a public agency delegates to a private entity a function that would ordinarily be fulfilled by the public agency, access to public records follows. In 2001, the first DCA upheld the criminal conviction of Vanette Webb, an Escambia County School Board member, for her refusal to produce public records in a timely manner. Webb had delayed the production of records for 6 weeks. In denying Webb's appeal, the first DCA concluded that Section 119.07, Parent 1, Parent A, provided Webb with fair warning that her dilatory responses to Watson's request would not comport with the statute's requirements that she provide reasonable access to public records in her custody. In 2001, the third DCA again addressed the issue of private entities and their relationship to public records. The Miami Herald had sought access to certain public records in the custody of Dade Aviation Consultant, a private entity contracted to work on behalf of Dade County. The court held that when a private entity undertakes to provide a service otherwise provided by the government, the entity is bound by the Public Records Act, as the government agency would be bound. In 2002, the fourth DCA held that even when access to public records is done for the sole purpose of harassment, the right to know may not be curtailed. The court opined that the motivation of the person seeking the records does not impact the person's right to see them under the Public Records Act. In 2009, the Associated Press sought access to records relating to the investigation of student athletes at Florida State University. The students have been accused of cheating and were subsequently investigated by the NCAA. FSU asked the NCAA to provide its attorneys with access to the NCAA's investigative records. The NCAA only allowed FSU's attorneys to view the records on a computer screen, but never allowed FSU or its attorneys to copy or download the records. When the Associated Press sought access, FSU claimed that it never received the records, and the NCAA claimed that it was not subject to Florida's Public Records Act. The First District Court of Appeals ruled in favor of public access. The term received in Section 119.011, Parent 12, refers not only to a situation in which a public agent takes physical delivery of a document, but also to one in which a public agent examines a document residing on a remote computer. If that were not the case, a party could easily circumvent the public records laws. The appeal by the university is a matter of public concern. It is not transformed into a private matter merely because the documents the university lawyers used to prepare the appeal reside on a computer owned by a private organization. As the plaintiffs expressed this point, the definition of a public record does not turn on the sender's method of transmission. Our conclusion that the transcript and response became public records when they were examined by state attorneys and used for a public purpose is supported by the decision of the Second District Court of Appeal in Times Publishing Company versus the City of St. Petersburg. It is clear from the historical record that the right to know is a civil right of the highest order, and that it continues to enjoy the unwavering support of the legislature, the voters, and the courts of this state.